Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case that was recently decided by the Supreme Court, or three cases. It's about the defense of extreme intoxication. If a person becomes so impaired by drugs or even alcohol that they don't know what they're doing, that they're essentially operating as an automaton, is that a defense for crimes that they commit while in that state? That's what the Supreme Court was recently asked to rule on in these three cases, Sullivan, Chan, and Brown. The individuals in those cases, Sullivan, Chan, and Brown, had all separately committed violent crimes while they were in what they argue was an automaton state. But under the existing criminal code, self-induced intoxication is not a defense for those crimes. Here today to talk about the case and what the Supreme Court decided are two lawyers, Connor Bildfell and Sina Shabastari. Thank you both so much for joining me today. Let's start by going over the facts of the three different cases briefly. These are unrelated cases, but because they kind of involve similar principles, they were heard together at the appeal. So Sina, what happened first in the Chan case?
Hi, Christine. Thanks for having me. So Mr. Chan had consumed alcohol with several friends and then voluntarily took some magic mushrooms containing psilocybin. When the first dose didn't work, he went back for a second. And once they started to kick in, he began acting erratically. And at first, he went to his family home, continued his erratic behavior, and ultimately ended up at his father's house, where he fell into delusions and thought that his father was Satan, and ended up stabbing his father and his father's partner. And sadly, his father passed from his injuries.
And he was quite young, wasn't he?
He was.
Yeah, do you remember how old?
I don't specifically remember his age.
Okay. But my recollection is that he was young, but obviously charged as an adult, I understand. Connor, what can you tell us about what happened in the Brown case?
Sure. Mr. Brown attended a house party where he consumed alcohol and magic mushrooms. Now, magic mushrooms contain a compound called psilocybin, which can bring about hallucinations. Mr. Brown basically lost grip on reality, broke into a nearby home, and attacked the occupant with a broken broom handle. And it's worth noting that the evidence was that Mr. Brown was not merely drunk or high. He was in a psychotic state and had no voluntary control over his actions. He was eventually arrested and charged with breaking and entering and with aggravated assault.
So I understand why those two cases were heard together. It's obviously both involving the same hallucinogenic agent, psilocybin. Sina, what about the Sullivan case, which was slightly different?
So Mr. Sullivan had a history of mental illness as well as substance abuse. He voluntarily took an overdose of a prescription drug that he was provided called Wellbutrin, which is something that is as an antidepressant. And he did that in an effort to commit suicide and fell into a drug-induced psychosis. And he became delusional and attacked his mother with a knife and injured her. Unfortunately, his mother did die, but not of the related injuries to the attack. And Mr. Sullivan, when police found him at the scene, was ranting in a delusional fashion, and similarly in also a psychotic episode, which resolved itself a number of days later.
Now, Connor, all three of these cases involved people who claim that they were not in control of their actions, but under the criminal code, a defense of self-induced intoxication is not available. What can you tell us about that?
That's right. So this case is all about the defense of what's called extreme intoxication akin to automatism. And in a nutshell, what the Supreme Court held in this case was that Parliament enacted an unconstitutional law. Section 33.1 of the Criminal Code prohibited accused persons from relying on this defense in cases involving harm to bodily integrity. But the Supreme Court held that the law was unconstitutional because it permitted an accused to be convicted even without proof that the accused committed the guilty act voluntarily or had the guilty mind necessary for a conviction. So, Christine, one of the fundamental tenets of Canadian criminal law that is reflected in the Charter is that we only punish people if they committed a prohibited act voluntarily and with the necessary guilty mind. The Supreme Court held that when someone's in a state of extreme intoxication that's akin to automatism, that renders them unable to voluntarily control their actions. And so the two conditions are not met.
Right. Connor, we've got to go to commercial break, but I want to delve deeper into this when we get back. Welcome back to Canadian Justice, where we're discussing a recent Supreme Court decision about the defense of extreme intoxication. So, Sina, Connor just kind of gave us a rundown of what the Supreme Court held, that this defense of this prohibition on using extreme intoxication as a defense, that was an unconstitutional prohibition. What about it made it unconstitutional? What about it resulted in the Supreme Court striking it down?
Well, specifically that it violated Section 7 and 11D of the Charter, being life, liberty, and security of the person, and presumption of innocence, which wasn't saved under Section 1. Effectively, as Connor indicated, it's the guilty mind, it's the mens rea that was lacking. And let's not forget, this is not something new. This is not something that's just come about now. For a number of decades, in fact, under Section 16.1 of the Criminal Code, an individual has been able to mount a defense of not criminally responsible due to some mental illness. Now, that's something prolonged, for example, in an individual suffering from schizophrenia. What it is that this similarly is trying to strike down a law that was preventing an individual from mounting a defense where they did not have the moral capacity or the moral wrongness in committing the act.
So, Connor, let's get into what this concept means. What exactly does it mean to be in this, automaton state? What do people need to prove to show that they were have this extreme intoxication? It's obviously more than just saying, "Oh, I was drunk. I didn't know what I was doing." What do they need to show?
Right, Christine. So there's a material difference between being an automaton and being simply drunk or high. Being an automaton means losing voluntary control over your actions. The courts have typically described this as a sort of a state of temporary psychosis. And it's not easy for accused to prove that state. The accused typically needs to call expert evidence, and that typically comes from a medical expert, showing that the accused had lost voluntary control over their actions. And as you mentioned, Christine, it's not sufficient for the accused to simply assert that fact.
Right. So Sina, the decision, this Supreme Court decision in Sullivan, Chan, and Brown, seems to suggest that the defense is extremely hard to make out and that it would really not be available for alcohol. So is that right? And why is that the case?
So both those statements are in fact correct. The Supreme Court stated in Brown that alcohol does not cause delusions or involuntary conduct. And they cited the expert evidence in the preamble of Bill C-72, which enacted the section which they struck down in the first instance. In fact, alcohol tends to have the opposite effect on those who consume it. Rather than making them act involuntarily, it decreases nerve cell activity over time to the point of unconsciousness and the impairment of movement. These effects are not consistent with automatism. And this defense is extremely hard to make out because it is not any level of intoxication that must be established. It is intoxication to the point of essentially becoming an automaton. And as the court stated in Brown, any claim of automatism must be assessed with reference to facts and expert evidence.
So Connor, what's your take on how common this might be as a defense? Is this something we're going to see a lot of? Is this something people should be worried about in terms of criminals doing bad acts and then showing that they were an automaton? Or is it very rare to get into this state? Is it something that we would see very little of?
Christine, in the past, the defense has been raised only occasionally and has succeeded only in the rarest of circumstances. Following the Supreme Court of Canada's decision, I think we may see a modest increase in the number of accused persons who raise the defense, but we're certainly not going to see a sudden wave of accused persons being accused or being acquitted on this basis.
Sina, same question to you. What do you think? Do you think we're going to see an increase in this being used as a defense, or is it just too high a standard to meet?
I think if there is an increase or an influx being used here, it's not by the virtue of the change in the law, but by the virtue of other substances other than alcohol becoming a little bit more socially accepted, such as magic mushrooms and psilocybin. So, and I don't believe that in this instance, given the difficulty of mounting this defense, that it would lead to an influx of individual effectively using this as a get out of jail free card. And let's not forget that a big part of what or is expert evidence, and an expert is always supposed to maintain in support of the court.
You kind of broke up a little there, but I think I get the gist of it, which is really that it's going to be very rarely available. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the defense of extreme intoxication for criminal acts and when it should be available. So, Sina, one of the ways that this case, Sullivan, Chan, and Brown, have been discussed in the media a lot is that this represents a get-out-of-jail-free card for someone who commits a terrible crime. These were all terrible crimes, very violent crimes. It's been kind of framed as a get-out-of-jail free card when someone does these crimes when they're drunk or high. And that's really not what the case does, obviously, as we've spent the first two segments talking about. So what can you say about why you think the case might be framed this way? And what do you think the accurate description of the case is?
I think simply put, clickbait, really. I think that the framing of this case in terms of get out of jail free card is something that also happened in Devialt as well, which was what led to the enactment of 33.1. The public reaction to the Supreme Court's decision is understandable, of course. There's concern for safety of the victims of intoxicated crime, who tend to be women and children. By the same token, the rights of an accused who loses the liberty for an involuntary act must be respected in light of the Charter. And this case is trying to reconcile these conflicting interests. The case is not really simply about being drunk or high. They're about the most extreme states of intoxication where the accused is essentially an autopilot. The court in Brown compared an automaton's conduct to that of someone's experiencing a seizure or sleepwalking, where they cannot control their actions or intent. And in Mr. Sullivan's case, he never intended to get intoxicated or commit aggravated assault. He was attempting suicide, and by this attempt, became delusional and lost control of his actions.
So, Connor, Sina mentioned a case that prompted this law, the case of Davio, which was from the 1990s. That was a case involving terrible crimes committed by someone who, in that case, had actually consumed alcohol. And the defense of extreme intoxication was pled, and the accused was ordered for a new trial on the basis of this self-induced intoxication defense. And as a result, there was a really large outcry over the possibility of someone drinking themselves into oblivion, committing a violent act, as happened in Davio, and then avoiding criminal responsibility. So do you think that history with the law might be contributing to some of the misunderstanding about the current three cases?
I think it absolutely could be contributing to that. I mean, the thing to understand about Davio is that it was an alcohol case. And alcohol cases are materially different from cases involving the types of compounds like psilocybin that we saw in a couple of cases that the Supreme Court of Canada heard here. And as Sina mentioned before, the Supreme Court of Canada here cast doubt upon whether alcohol could even potentially result in this defense. The medical expert evidence did not suggest actually that alcohol can bring about the type of automatistic behavior that we've seen with psilocybin. And so I would just emphasize it's important to recognize the distinctions between those types of cases. The circumstances and the nature of those cases are actually materially different.
So, Sina, sort of same question about this original Davio case, which, as I said, involved alcohol. Do you think that case would today be treated differently after the Sullivan, Chan, and Brown decisions, where alcohol-induced extreme intoxication seems pretty clearly outside of what can be available for this defense?
Indeed, I think the facts of Davio would not constitute a state of automatism as is indicated by these three cases and the Supreme Court striking down Section 33(1) of the code.
So, Sina, I also want to talk about the different intentions in this case. So, in some of these cases, the accused intended to become intoxicated. They intended to have fun. It was recreational use of psilocybin. But in Sullivan's case, he was not intending to get intoxicated. Does that make any material difference? He was trying to commit suicide. So does that matter in the court's analysis at all?
I think what really matters is when we're talking about their intent, it's the end result, the intention that matters. And what's important is I don't believe one can intend to become an automaton. The very phrase in and of itself, automaton, is automatic. It presupposes a lack of intent. However, automatism is a state of intoxication. Mm-hmm. I think as lawyers, what we should do is give light to meaning, and what's important are the factual backgrounds in terms of how was it that they came to be in that state of intoxication, and what were the facts prior.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the defense of extreme intoxication and when the Supreme Court has said it's available. I want to talk briefly, Sina, about the Brown case and the context of the offense. In that case, it was a person who had consumed magic mushrooms, psilocybin, committed a violent act. Anything you can add to the context of the offense and how it relates to automatism as a defense?
Indeed, and certainly voluntary automatism, as we had indicated. I think in Brown, what's important is to note that he didn't have a history of violence, no mental ailments previously. He was consuming this drug in a safe environment with his friends. He did not foresee what could come about as a matter of ingesting them. And ultimately, the court did go through lengths of discussing these things. The circumstances in which substances are consumed and the results of them are very important.
It's certainly a terrible, terrible set of facts in all three of these cases. Now, Connor, since this law has been struck down, what might we expect Parliament to do in this case? Obviously, the law was originally acted in response to another case involving self-induced intoxication in Davio, as we talked about. So might Parliament revisit this law and change it and reenact it in a slightly different form?
Absolutely, Christine. There is absolutely a possibility that Parliament will rewrite this law. And in fact, the Minister of Justice, David Lametti, has already indicated that the government is considering its options, but is not committed to any particular option. In the Supreme Court of Canada's decision, it actually carved out a number of different alternatives that Parliament could pursue. So, for example, we could see a new offense of dangerous intoxication causing bodily harm. And that offense could be drafted in a way that is sufficiently nuanced to fix some of the constitutional infirmities that the Supreme Court of Canada identified in its decision. So to answer your question, yes, we could absolutely see a rewriting of this law, and the ball is now in Parliament's court.
Sina, anything you want to add there about the possibility of Parliament rewriting this law now that it's been struck down?
Indeed, I think Connor has hit the nail on the head. It's something that the Supreme Court discussed specifically in Brown, a number of options that Parliament could do, and this is something that will not go unaddressed.
Connor, just in our last few minutes, I want to talk briefly about the balancing here, because I do understand a policy rationale. We don't want someone to get away with a crime because they got themselves, drunk or high. We want people to be responsible for their actions, including the choice to become intoxicated to the point of automatism. So what's the balance here? Do you think the court got it right?
Well, Christine, that's a great question. The Supreme Court of Canada grappled with this question head on, and it recognized the important policy objectives that Parliament was pursuing. But at the same time, the court recognized that there are limits on what Parliament can do. And one of those limits is the constitutional rights of accused. And there's a way to give effect to Parliament's accountability objectives and its objectives of protecting individuals who are the victims of crime, without violating an accused's charter rights. And that's what I'm hoping to see from Parliament. I think that's the right path forward, is to carve out a more nuanced law that strikes a better balance between the rights of the accused and the important policy objectives that Parliament is pursuing.
Sina, anything you want to add to that? Because as we've said, we understand the policy here. We want people to be held accountable for getting themselves into a dangerous state, but we also obviously want to preserve people's constitutional rights. Just 1 minute.
For sure. I think while we want people to be held accountable, but we only want that where it's appropriate. This is not at all to say that the person got themselves so intoxicated for the purpose of committing a crime and later arguing that they were in a state akin to automatism. Some people like Mr. Brown have little to no foresight of getting themselves into a dangerous state. And some people like Mr. Sullivan attempting to take his own life didn't do that on purpose in terms of the ensuing act. They put themselves in a dangerous state of intoxication. And we shouldn't hold people who do not have the requisite guilty mind or are in a state where they're not capable of knowing something is morally wrong accountable under the law.
Well, Sina Shabastari, Connor Bildfeld, I want to thank you both so much for coming on today and really giving this case the deep analysis it needs.
Thanks, Christine.
We've heard today about the defense of extreme intoxication and 3 cases that were recently decided by the Supreme Court. The cases are brand new, but they've already been frequently misinterpreted. The defense of extreme intoxication, or automatism, will be very rarely available and only in very extreme cases. Thanks for watching, and remember, a freer Canada starts with you.